yet another VCM on reassessment, and that too in faceless regime, and it is a real way forward. And to know further about the reassessment, we have none other than CA Nitin Mehta, advocate from Ahmedabad, to deliberate on such an critical topic of reassessment. We are fortunate to have with us CA PC Sarda sir as the chief guest of today's session. We also recognize the presence of past chairperson and past vice chairman of WRC CA Julfesh Shah sir. We welcome you all. To begin now, may I now request chairperson of Nagpur branch CA Jiten Saglani sir to give his welcome address. Jiten sir, over to you.
Thank you so much, CA Akshay. Chief guest of today's session, senior and very respected CA PC Sarda sir. Speaker of today's session, very knowledgeable, CA Nitin Mehta, advocate G from Ahmedabad, and despite his very busy travel schedule, he has connected himself from Hyderabad. Past vice chairman of WRC and past chairman of Nagpur branch, CA Julfesh Shah sir. Colleagues in the managing committee, CA Akshay Gulane, the secretary, CA Dinesh Rathi, the treasurer, CA Ajay Vaswani, the managing committee members, other managing committee members who will be joining shortly, seniors in the profession, and all my dear friends. A very good evening to one and all, and I welcome you all to this VCM on reassessment the way forward. Friends, I first wish to thank CAPC Sarda sir for accepting our invite on a very short notice and being the chief guest of today's session. Sir, thank you so much for connecting and gracing this program. I also wish to thank CA Nitin Mehta sir because he had been so nice and kind. And to bring him on board at Nagpur branch, I wish to thank CA Julfesh Shah sir, along with that CA Rajesh Surana ji, because these both stalwarts had been very instrumental in helping us to talk to Nitin sir and make us connect. And now we are here with him, and wherein we'll be having a very important topic of reassessment. Friends, reassessment has become very relevant after the decision of Supreme Court, and with the change in regime of reassessment by introducing Section 148A of the Income Tax Act with effect from 30th June 21. It is now very pertinent for practicing professionals to understand the various practical aspects when it comes to handling notices, that too issued under Section 147, and further handling of reassessment. So basically, to keeping this in light and this in mind, we had thought of this session, and thanks once again to CA Nitin Mehta ji for accepting our invite and being here on board at the Nagpur branch forum. Friends, I hope that this session would be very enlightening one. It will be a real enrichment to your knowledge, and I believe that very soon most of us will be having some or other notices, and this discussion today will be definitely helping us out to sort out those issues. Friends, talking about the future programs, we have on 2nd of June, that is coming Friday, we have a session on foreign FCRA, that is Foreign Contribution Regulation Act, an overview, which will be actually organized by Nagpur branch, and a speaker therein is Miss Isha, CA Isha, that is coming. She's coming from Bombay. We have another session on IBC, which is actually
Thank you so much, Chairperson sir. Definitely, as you rightly said, 148 and 148A are now the way forward, and we professionals are ready to tackle it. But furthermore, we have Nitin Mehta sir, who is going to deliberate on that. We are fortunate to have CAPC Sarda sir as a chief guest, a stalwart who is going to, who always, in support of Nagpur branch. To formally introduce PC sir, I request Treasurer of Nagpur branch, CA Dinesh Rathi ji, to kindly introduce him. Dinesh sir, over to you.
Thanks, Akshay. Dear all, it's indeed my honor to introduce today's chief guest, CA Sarda sir. Sir has done his schooling in West Bengal in Bengali medium and did his graduation from GS College, Nagpur. He completed his Chartered Accountancy course in 1983, and since then, he has been partner in Gupta Sarda Bagadia and is heading taxation and audit field of the firm. Sir has delivered various lectures in study circle meetings and seminars. He has been joint editor of Nagpur branch bulletin in 1998, 1999, and 2004. He has been co-opted members of Auditing and Assurance Standard Board, Professional Development Committee, and Board of Studies. And he has been member of Regional Direct Taxes Advisory Committee constituted by Chief Commissioner of Income Tax, Nagpur. Sir, I, on behalf of all the Nagpur branch committee members and all the delegates here, welcome you. Thanks. Thanks a lot. Over to you, Akshay.
Thank you so much, Dinesh sir. I request PC Sarda sir now to kindly address the gathering.
Thank you, Akshay. And thank you, Dinesh, for a very nice introduction. Chairman of the branch, Nitin, past chairman and past vice chairman of Regional Council, CA Julfesh Shah, secretary, yourself, treasurer, Dinesh ji, and others, I don't think I've seen. Ajay is there. Thank you very much to all of you for giving me this opportunity to chair this important session today. In fact, as looking to the various programs outlined, it is very good from the part of the Nagpur branch to conduct various VCMs. In fact, including today's 3 VCMs are scheduled for up to 4th of June. That is very good thing from the Nagpur branch for updating the knowledge of the professionals. Now, about today's topic, reassessment, the way forward, or as Mr. Mehta ji has headed his, put headline on his, the new paradigm, whatever it is. We all know that much water has flown. We have crossed so many paths relating to this new tax reassessment design. Starting from the old sections which were there, section 147, 148, 149, 151, the new design was introduced by Finance Act 2021. The controversy started when the department issued notices, reassessment notices, post 1st April 2021, about by taking benefit of TOLA from 1st April to 30th June 2021. These notices were contested by the SSEs mainly on the ground that 2 sets of provisions cannot exist simultaneously, and that view found favor with various high courts, including Allahabad High Court, Bombay High Court, Calcutta High Court, Delhi High Court, Madras High Court, Rajasthan High Court, barring one decision favoring the department. All other decisions were in favor of the SSEs, quashing or setting aside the reassessment notices, mainly on the ground that these notices cannot be issued after enactment of the new provisions for reassessment. The matter went to Supreme Court, and Supreme Court, by its landmark judgment on 4th May, took a very balanced view. It accepted the reason by which the various high courts has quashed or set aside the assessment notices. but at the same time gave some leeway to the department by taking recourse to the powers conferred on it via Article 142, that is asking, making the notices issued under Section 148 to have been issued under Section 148A, and doing away the requirement of having a prior approval, etc., as specified in 148A. Now, up to that, it's okay. But then came the government's CBDT's instruction, that is 1 of 2022 on 11th May 2022, by which the CBDT said, except assessment year 13-14 and 14-15, where reassessment notices for income escaping assessment below 50 lakh cannot be issued. The rest all can be issued, and provided a timeline within which the other compliances can be done by the assessing officers. Now, the way forward is how to deal with this situation, because there are various interpretations, particularly first proviso to Section 149(1), whether this looking after this proviso, whether notices can at all be issued related to assessment year 13-14, 14-15, the matter to be examined. We have today with us a very learned faculty in the form of CA Nitin Mehta ji, who also happens to be an advocate, who has kindly consented to give his views on these aspects and show us the light in the new paradigm, as well as the way forward in these reassessment procedures. Apart from this, what other recourse, how to deal with the 148 notices, what technical ground can be taken for the purpose of benefiting the SSCs, and he will also guide. I am sure will be much wiser after hearing his deliberation today. I once again thank Nagpur branch for giving me this opportunity to chair the session. Thank you very much.
Thank you so much, PC sir. We always know that you are always there for Nagpur branch to guide and mentor us. Thank you so much for gracing the occasion, sir. Furthermore, may I now request Managing Committee member CA Ajay Vaswani to formally introduce Speaker of the Day, CA Advocate Nitin Mehta, sir. Ajay, over to you.
Thank you, Secretary, sir. Good evening, gentlemen and ladies. And it is indeed a privileged opportunity to introduce Advocate CA Nitin Mehta, sir, on behalf of Nagpur branch of ICAI. Sir is a qualified chartered accountant and advocate both. In initial years, he was practicing as a chartered accountant, and after that, he switched over to practicing as a lawyer. And it has been over 2 decades now he's been doing so. And he's also a graduate in commerce and the 2 additional qualifications, diploma in information system audit, where he stood 9th in the merit list, and also he has qualified to be diploma in international trade laws. He joined the chambers of Mr. Mihir Thakore, senior advocate, and got trained as a civil and a corporate lawyer for 10 years before starting his own firm. He was a special appointee by High Court of Gujarat as a youngest advocate to represent official liquidator before the High Court of Gujarat. He was special appointee by CBDT to represent income tax department in the very famous case of Vodafone. And he has been appointed as the youngest senior standing counsel by CBDT to represent income tax department in High Court of Gujarat during that period from 2013. He had jurisdiction of Ahmedabad and international tax and transfer pricing for Gujarat, Rajasthan, MP, Chhattisgarh. Despite not offering himself for the second term, he was still requested to continue for 1 additional year. And furthermore, he specializes in direct tax and indirect tax, commercial dispute, corporate law, and IPR matters, with special focus on economic crime matters like Benami, PMLA, prosecution under tax laws. He has appeared before various high courts, NCLT, ITAT, SESTAT, TRT, and various multiple appellate forums along with. He has led litigation disputes cumulatively worth more than 40,000 crores and has several Sensex companies as his part of clients. He is a regular speaker on various topics. Participants to welcome a very renowned faculty for the day, CA Nitin Mehta sir, with a big round of applause. So we welcome you at Nagpur branch of ICA.
Thank you so
Over
much,
to you, Akshay.
Ajay. Thank you so much. Without wasting any further time, may I now request CA Nitin Mehta sir to kindly take forward the session. Nitin sir, we are eagerly waiting to listen to you, sir.
A very good evening to everyone. Mr. Purushottam Sarda ji, whom I have heard a lot from Mr. Surana, Mr. Julfar Shah, Mr. Shah, who has been instrumental in letting me have an opportunity to address this August gathering. Mr. Jitendra Saglani, chairman of the branch, and the other office bearers, it is indeed a privilege to be here today addressing one of the most highly regarded city from where we have got, as we say, God in our profession, Mr. Harish Salve, who fortunately is also a chartered accountant come advocate. And to say that Nagpur is the center of India, the stalwarts from Nagpur have been the center in litigation since long. Two names, certainly Mr. Harish Salve and one of the most revered advocate, who according to me is a living legend even today, and I adore him, is Mr. Manohar. So it is a great pleasure of mine today to address people and members from that city. Today's topic, as they say, that there are only two things certain in life: A, death, and B, being taxed. So the second certainty is something which we all accepted while being assessed originally under 143(3) or under such initial provision. But the law wanted was not satisfied, and the legislature wanted us to revisit this certainty, and therefore it introduced something like a reassessment procedure under section 147 to 153, doubly ensuring the certainty of being taxed. That apart, there were sweeping changes brought about in Finance Act 2021, which tried to simplify things, compliance, and in fact reduce litigation. With this object, Finance Act 2021 was brought into play. But as they say, that revenue has its own mind. The executive wanted to go whole hog, and without appreciating the purpose of this new law, they went ahead and implemented the old law with effect from 1st April 2021. As Mr. Sarda has rightly pointed out, that there were notices which were issued for assessment years under the unamended old law, which the Parliament wanted to be effective only up till 31/3/2021. Notices came to be issued, came to be challenged before High Court, essentially on the ground that with the new law being in place, the old law has no legs to stand. There was no saving clause, and therefore the notices need to be quashed since it did not apply the law in vogue. Accordingly, the high courts, 9 high courts, understood, and I would, in my last 2 decades of experience as a lawyer, say extremely brave of them to actually uphold the rule of law, which was to lay down the law and declare it that it was only the new amended section 147 to 153, which came into effect from 1st 4/2021, would apply to all those notices which came to be issued post 1st April 2021, and therefore quashed all those notices issued under old law post 1st April 2021. Extraordinarily brave act, and fortunately not one, but 9 high courts did the same. I believe our Gujarat High Court from my parent High Court was also about to do that, but before it could do, the revenue went into appeal in Supreme Court, and the famous Supreme Court judgment came to be passed on 4th May 2022. Now, as Mr. Sarda has rightly pointed out, that while we were trying to understand the interplay between the old and the new regime, the new law, I would say a completely new law in terms of the Supreme Court using its extraordinary powers under 142 of the Constitution, made things even miserable for the assessees at large to actually understand and decipher the interplay now between the old law, the new law, and what Supreme Court has stated and the procedure which it has laid down. So with the permission of the organizers, may I share the screen? I hope the screen is visible to everyone.
Yes, sir, visible.
Visible. Fine. Now, therefore, today we will try to decipher and understand what the Supreme Court meant while it delivered its judgment in Union of India versus Ashish Agarwal. Two judges, it was a two-judge bench led by Justice M.R. Shah, and it's as latest as 4th May 2022. As the background has already been laid down by Mr. Sarda, the notices which came to be issued post 1st April 2021 under the new law came to be challenged by High Court, which decided and quashed those notices, and such notices came to such orders of the High Court Allahabad being the first, came to be challenged before the Supreme Court. While the matter was being heard in Supreme Court, the Supreme Court itself has listed that there are other 8 high courts who have held in favor of the assessees, while one, the sole High Court of Chhattisgarh, which held against the assessee. And therefore, the Supreme Court, if I would just want to, I will in detail take what Supreme Court has held. Just, I would put the Supreme Court 34 pages judgment in 4 categories. First being, we'll need to understand what is the law which has been declared by Supreme Court. Second, that apart from declaring law which it does under 141, Article 141 of Constitution of India, it used its extraordinary powers under Article 142 of the Constitution of India and deemed certain things. We'll come to it. It deemed that Section 148 notices are deemed as notices issued and as show cause notices issued under 148A in bracket B. Third, it lays down the procedure, which is one-time procedure, as to what would happen post its deeming the notices to be a show cause notice under 148AB. And then there are certain miscellaneous things which is as observed, which we will come to in greater depth. Now, Supreme Court, if we broadly consider, we have today the judgment of Supreme Court which holds that the notices which came to be issued by government, by department, were notices which were issued under old 148. The Supreme Court categorically stated that such notices could not have been held or issued by the revenue under the old law post enactment of Finance Act 2001. Interestingly, Finance Act 2001, the emphasis of it is seen from the very fact that it is used 10 times in the entire judgment without any emphasis to preceding years of 2020 of Finance Act 2020 or any preceding years. Now, what Supreme Court has said, or what is the law which is laid down? The law which it has laid down is saying that high courts were right in holding that the new law would be applicable and the old law could not be applied by the revenue authorities. That is one aspect of it. So we will have to understand the Supreme Court has not elucidated as to what high courts have in detail held, but has just concurred with the opinion expressed by the High Court, and therefore in that sense validating the law laid down by the High Court. Next to it is having declared that the notices are bad in law, since that is what High Court has said. Supreme Court goes ahead and states that under the new Finance Act 2021, there is an addition of Section 148A, which we will in detail understand later. But just for the brief clarification for the audience, Section 148A lays down the procedure which GK and Reichschaft, by way of judicial declaration of law, had held, thereby stating that the procedure to be adopted before issuance of notice under section 148 and proceeding with the assessment, which is that the inquiries must be held by the assessing officers before reopening. A show cause notice needs to be sent, that needs to be replied, that reply needs to be considered by the assessing officer, and he has to pass a order under section 148A in bracket D, and only thereafter can it issue notice under section 148. Now, the resultant, let me share the Supreme Court judgment also so that we all can have the benefit of it. Now, the Supreme Court held, the reasons which it gave was that section 148A under the new regime is a game changer and is in the nature of condition precedent for issuance of notice under section 148. And the purpose of bringing in the new provisions by Finance Act 2021 was to simplify the tax administration, ease compliance, and reduce litigation. These, the Supreme Court held, are in public interest, and therefore the High Courts were absolutely right. The High Courts have rightly held that the benefit of the new provision shall be made available even in respect of the proceedings relating to past assessment years, provided section 148 notice has been issued on or after 1st April 2021. We are in complete agreement with the view taken by various High Courts. Now, having held this, the Supreme Court was moved by the argument of the revenue, which was done by ASG Mr. N. Venkatraman, and he's my guru, who has really taught me how to present matters, and the lethal combination of his with Honorable Justice M.R. Shah, who actually has really challenged me to improve with every case I have argued before him. And therefore, in that sense, the lethal combination of Mr. N. Venkatraman with Honorable Justice M.R. Shah, for whom hundreds of matters I have argued in Gujarat High Court when he was there. The introduction done by Mr. Venkatraman was saying that there are 90,000 notices which have been issued during this period beginning between 1st April 2021 to 30th June 2021. And all these judgments, all these notices will, if the High Court judgment is applied, will be quashed, leaving no opportunity for the assessing officer to actually assess, and therefore there will be loss of exchequer. Now, this moved the Supreme Court that giving no opportunity to the revenue to assess based on their wrong application of the law, which, as argued by learned ASG and accepted by the Honorable Court, was a bona fide mistake. Whether a bona fide mistake can be done by one officer or continuously by numerous officers having issued 90,000 such notices applying the old law, or whether the ignorance of law is equivalent to a bona fide mistake. The argument which was placed before the Supreme Court, we need to understand to really resolve the issues arising from the judgment, was this, that the assessee before the High Court argued that these amendments with effect from 1st April 2021 were procedural in nature, and therefore that would apply to all the reassessment notices or proceedings which are initiated post 1st April 2021. While the revenue argued that it was a substantial law, and therefore the substantive law being the old unamended 147, 148, the same will apply to notices issued post 1st April for prior years. High Court held in favor of assessee, as we have all known. The Supreme Court, without actually mentioning here that the distinction between substantial and the procedural law, moved along with, I would say, the emotions placed by the revenue of losing the exchequer, the public exchequer, from all those notices which were issued during that period, without realizing that there were notices issued between 1st April to 30th June 2021. If the new law permitted, they could have been reissued if the new law permitted, which Delhi High Court held at the end that the revenue is permitted to reissue the notices if available under the new law. Therefore, what Supreme Court decided was to not give an opportunity to revenue to contest or to proceed with its notices which it held bad in law, by deeming that, I may just read the wordings, the impugned section 148 notices issued to respective assessees which were issued under unamended section 148 of IT Act, which were the subject matter of writ petition before the various respective high courts, shall be deemed to have been issued under section 148A of the IT Act as substituted by Finance Act 2021 and construed or treated to be show cause notices in terms of section 148 small b. The assessing officer shall within 30 days from today provide to the respective assessee information and material relied upon by the revenue so that the assessee can reply to the show cause notices within 2 weeks thereafter. Therefore, it is deemed now that the notices which have been issued are under erstwhile 148 is to be treated as show cause notices under new 148A. Now the question which arises is why it is so important the period between 1st April 2021 to notices issued between 30th April 2020 30th June 2021 is so relevant. For that, we will have to go back to the old law, old 149. If you would recollect that in old 149, the period for issuance of notices were twofolds. One was up to 4 years, and second was beyond 4 years, that was up till 6 years. Now, therefore, the 6 years would come to an end on 31st March of each respective years. The issue came that the assessment year 2013-2014, the 6 years under old law would get over on 31st March 2020. That is 6 years. Now, as we all know, the world was under lockdown, especially India, and therefore the notices could not be issued in time. The government came out with ordinances for extending the time to issuance of notice. Later on, that got converted into act, and that act was called in short TOLA, which is under section 3 of TOLA, that empowered to the executive under law to in fact, that particular section itself provided that all the notices from time to time which had been issued, which has been extended from time to time, right from 31st March 2020, it provided that all those will be extended up till 31st March 2021, and also empowered the assessing officers, or in fact the executive, to issue notification for further extension of the same. It is on the screen if everyone can see. So what it says was, I may just read that, where any time limit has been specified in or prescribed the specified period so and so, the central government may by notice specify in this behalf for completion or compliance of such action as so, and where completion or compliance of such action has not been made within such time, then the time limit for completion or compliance of such action shall, notwithstanding anything contained in the specified act, stands extended to 31st day of March 2021 or such other date after 31st day of March 2021. Now, according to such power, there were several ordinances which was issued, or notifications which were issued, which extended the power and extended the limitation as seen in the screen. The last extension extended it up till 30th June 2021, and therefore the argument of the department that they had power to issue notices for all the assessment year 13-14, which was about to end on 31st March 2020 till and up till 30th June 2021. Therefore, it issued. Now, the question arises whether the new notices which the Supreme Court has deemed to have been issued under 148A subclause B, whether such notices would be issued as if they had been issued today, or they have been issued as on the date on which the original 148 notices under erstwhile law were issued. And if that be so, then whether under 141 under 149, section 149, the power to issue notices, the time limit to issue notices under section 148 is available or not. One set of argument which has been laid down from the assessee side is this, that there are two views on this: A, the assessee's side, and B, I would say the revenue's contention. Since I can't help but think from revenue side as well, being their advocate for almost 4 years. The assessee contests that such notices, though deemed, cannot extend the period of limitation as provided under 149. The basis of their argument is the Supreme Court holding under its judgment that all the defenses available with the assessee as well as the revenue under all the provisions under income tax, especially mentioning section 149, will be available, and therefore the assessee is arguing that A, the defense under 149 has not been closed by Supreme Court. Accordingly, the Supreme Court has not held that the limitation has been extended. TOLA has not been applicable to the new regime under 149, which has been amended under Finance Act 2021. 2, 3, the argument essentially is that what TOLA did was only to extend the notices which have already been issued prior to 31/3/2021. Those and the compliance and the conclusion of its assessment have been extended till 30th June 2021, and not the right to issue fresh notices. This itself really does not lay down any particular emphasis, because what Supreme Court has said that it agrees to High Court, and therefore to say that by the assessee that TOLA is a separate act, and while interpreting the new provisions which has been made applicable by Supreme Court and accepted by it as a declaration of law, will not have as interplay the provisions of TOLA, which also is, by the way, is a central act. Supreme Court is silent on it. On the other side, the revenue is very categorical, saying that TOLA is a central act. Under the powers given, the central government extended not only the completion but also the compliance, and has specifically mentioned in subsequent notification. Is it visible on the screen? Hello. Yeah, is the PPT visible, sir?
No, sir. It is not visible.
Not visible. In a second. Is it visible now?
Yes, sir, visible.
Okay. So,
Sir, can we make the PPT full screen?
yeah, one second. Problem is, yes,
Fine, sir.
yes. Not moving forward. I'll have to really share it once again. 1 second. Um,
Sir, PPT is not visible once again.
yeah.
Right, sir.
In a second. So I'll just make it visible 1 second.
Yes, sir. Friends, till that time, I request to kindly mention the queries if you have any in the chat.
हमको 40 घंटे करना कंपलसरी है.
Nitin sir, you are mute, sir.
Yeah. So let me put it this way. Now the the notification has stated that till notification at least issued till 31st March 2021, there was no specific mention of time limit under section 149. This mention of section 149 only came by way of notification which were issued in April 2021. So the argument made by the assessee was that there was no extension even considering the revenues argument. And revenue, sorry, it's getting bad. Now, I would just open the house to say that according to the members, according to them, what is that which they are finding it to be more appropriate, the argument made by the revenue or that of the assessee. Let me again very simply put it. Revenue says TOLA is applicable, and because of TOLA, the time extended from 30th March 2021 to 30th June 2021, and therefore the notices could have been issued under the old law up till 30th June 2021, and all such notices which therefore have been issued are valid under law. The other argument of the assessing of the revenue side is this, that notices what has been declared by high courts is only that the procedure. High courts actually held, there were two issues before the high courts. One was the extension of the time, and second was an explanation which is before on the screen. Now I think it is visible. The explanation was that they had made the provisions of the old law also applicable to such notices issued between 1st April to 30th June, which I will call it as the contested period, to simplify things rather than repeating it again. So for this contested period, they made the old law also applicable. The department says that what has been washed apart from the notices, is the notification to the extent that it made the old law applicable to the notices issued under the disputed period, but not the extension of the notices to be issued in the extended period. Supreme Court has not said anything but to say that we agree with the High Court. If there is anyone who would want to really throw his hat in the middle and give his viewpoint as to which and why they would agree to, anyone can probably mute and I'm sorry, unmute and say, is it possible? Is it possible, or should I go ahead? Okay, so according to me, the entire aspect turns on what the high courts have said. If the high courts have said that you could not even extend the time period for issuance of notice, the Supreme Court has also agreed to that statement of law by High Court. However, if the High Court has only restricted itself to actually invalidate this explanation which applies the substantive provisions of the old law to the notices issued, then what department would say is probably the revenues argument would be standing and saying that all the notices which have been issued up till 30th June will have to have whole hog. Now, this was the first issue which we will come slightly more in depth. The second issue is whether this particular judgment will be applicable to all. The Supreme Court has stated that there are 9,000 writs which have been filed across India, and there are 90,000 notices which have been issued. So around 81,000 notices were not challenged before in a writ forum before the Honorable High Court. My poser is whether this Supreme Court judgment is applicable to all 81,000 or all 90,000, or it is only applicable to the 9,000 which went into the High Court either by way of and which may be pending at any stages. The stages could be that the matters are just filed, not heard, quashed, notices quashed, heard but judgments awaited, heard, no stay granted, heard and dismissed the way Chhattisgarh has done. So in all these respects, the matters were before High Court. Again, I would have an open discussion if anyone wants to pitch in as to whether this Supreme Court judgment is applicable to all 81,000 also, or only to the 9,000. The popular view, which is based on two words which have been used by Supreme Court, is that this judgment is applicable pan-India. If it is everyone can see on the screen, the present order shall be applicable pan-India, and therefore it has been widely believed that this judgment will also apply to all 81,000 notices which have not been challenged before the High Court. However, I have a different take on that. My take is that the Supreme Court, as I have told, have done two things. One, declared law under Article 141, which will definitely be a precedent for everyone to follow, which is that high courts were right in applying the new law. B is applying Article 142A pars by treating 148 notices as show cause notice under 148AB. In my view, this power of Supreme Court under 142 has very restricted applicability and is not a declaration of law under Article 141, but is applicable only to the parties to the list. Though Article 142 clearly states that the jurisdiction to which this law will be applicable is the territory of India. But that is to say that this law will be applicable, the law declared under 142 will be applicable to the territory of India with respect to those to whom this law has been made applicable, which essentially are the parties to the list. The Supreme Court in Ashish Agarwal, according to me, has applied this law not only to the writ before it or to the challenge or the party before it, which was Union of India and Ashish Agarwal, but expressly made it applicable to all writs which are at any stage before high courts, and that to high courts pan India. And in that context, I believe this word, this phrase pan India must be read as. Therefore, I am reading only two places where pan India has been referred to. The first one is at para 9, where I may just read the entire sentence so that the background will be why I am saying what I am saying. We have also proposed to pass the aforesaid order in exercise of our power under Article 142 of the Constitution of India by holding that the present order shall govern not only the impugned judgment and orders passed by the High Court of Jurisdiction of Allahabad. Now, just halting here for a moment, why Allahabad? Because that was the impugned order in case of Ashish Agarwal, which was being debated or litigated or argued before the Supreme Court. Therefore, Allahabad High Court, but shall also be made applicable to in respect of similar judgments and orders passed by various high courts across the country. So what it says is, though we are hearing the matter from Allahabad High Court, we are making it applicable to similar judgments and orders across various high courts in India or across the country, and therefore the present order shall be applicable pan-India. So here the word pan-India has to be read in context of the high courts which are across the country and therefore pan-India. And it is in context of this particular sentence, we have to further read in para 11, where again pan-India word is stated. I may read it. The present order shall be applicable pan-India, and all judgments and orders passed by different high courts on the issue and under similar notices which were issued after 1/4/2021, issued under section 148 of the Act, are set aside and shall be governed by the present order and shall stand modified to the aforesaid extent. The present order is passed in exercise of 142 so as to avoid any further appeal by revenue on very issue by challenging similar judgments and orders with a view not to burden this High Court with approximately 9,000 appeals. Mind it, it is not saying 83,000, the balance 81,000. It is saying 9,000 appeals. We also observe that present order shall also govern the pending writs pending before various high courts in which similar notices under section 148 of the Act issued after so and so are under challenge. So therefore, again in para 12, the impugned common judgment and order passed by the High Court of Allahabad and similar judgments and orders passed by High Court, more particular respective judgments and order passed by various High Court particularly, of which are mentioned here, stand modified, substituted to the aforesaid extent only. So the modification, therefore two things, holding High Court order to be valid, but to the extent of quashing, it says that I am quashing the notices, we are incorporating 142 deeming friction, and therefore to that extent 9,000 appeal we do not want to hear, and let this order be applicable to all 9,000 pending writs before various high courts. This is one view. The second view obviously is a broader view that Supreme Court cannot discriminate between those who have gone in writ, and there cannot be prejudiced more than one who have not gone in, not filed a preferred writ and have gone ahead with their assessment proceedings. That's an argument, certainly. But there are reasons why I'm saying so. The first reason, there are certain judgments which I would want to evoke in light of my justification for the same. The judgments have stated very categorically that the power of issuance under Article 142 have
Nitin sir, I think there is some technical issue. You are not audible, sir. Friends, he is rejoining. Kindly bear with us. Till the time, I request the participants, if you have any query related to reassessment 148 or 148, so kindly mention the query in the chat box so that the speaker will be prepared. Till the speaker joins, I request PC sir, if you can highlight the catch points and what professionals should.
Well, the controversy which he is raising about its pan-India applicability, his argument is definitely there. If we read the entire, am I audible?
Yes,
am
sir.
I audible?
Yes, sir, you are audible.
The controversy has been well explained by reading the various lines and the various paras of the judgment. And in his view, it is applicable only to the cases which are either decided by the High Court or there in the High Court, but not in the cases where no litigation has been entered into. But the CBDT circular, this instruction dated 11th May 2022, that is instruction number 1 by 2022 in paragraph 5, categorically states, taking into account the decision of the Honorable Supreme Court in various paragraphs, it is clarified that the judgment applies to all cases where extended reassessment notices have been issued. This is irrespective of the fact whether such notices have been challenged or not. Sorry, sir.
No. I am sorry. Technical issue. The light got disconnected. Therefore, the Wi-Fi connection.
Okay.
Extremely sorry. In Ahmedabad, generally light never goes, so it never comes to our mind that there has to be an inverter or something, some provision of it.
Right,
Though
sir.
I am in Hyderabad, the IT capital city, post Bangalore, you can really debate. Extremely sorry for this inconvenience. But it has just come, and I've just connected from my mobile also.
Okay.
Um,
Can you share the screen?
Yeah. In a second, sir. In a second.
That's the constantly here.
Is the screen?
Yeah, it's visible.
Yes, sir.
Right. So I was on the powers. I was on the power under Article 142. Now, Mr. Sarda was reading a very relevant portion. As I told you that there are two views definitely, and the more popular view is that this is applicable pan pan India. Interpreting pan India, it is applicable to all SSE irrespective, or in our words 90,000 show cause notices. But my view, based on the wordings and the power of under Article 142. Under Article 142, it does not declare the law. It has a power in the interest of justice to do complete justice. The word is complete justice. And in fact, the Supreme Court in Ashish Agarwal does not use the word the phrase complete justice. Article 142 has to be evoked to do complete justice, which has not been used by the Supreme Court, though it has said that balancing act and public exchequer and interest of and public interest at large. But what is that Supreme Court could at max do? So Supreme Court, this is very latest judgment, latest in the sense 20 years back, but one of most celebrated judgment. I may just read it because this will be helpful to us in subsequent interpretation of this judgment as well. Article 142 being curative and in nature cannot be construed as power which authorizes the court to ignore the substantive right of the litigant while dealing with a case pending before it. Article 142, even with the width of its amplitude, cannot be used to build a new edifice where none existed earlier by ignoring express statutory provisions dealing with subject and thereby to achieve something indirectly which cannot be achieved directly. This is the constitutional bench judgment. And also in AIR 2000 Supreme Court 360 3638, Supreme Court has said that such power under Article 142 is not available with High Court. So the incidental observation of Supreme Court that High Court could have done this, they did not have a power to do it. Let's be very clear on it. Now, here is this Supreme Court judgment of 2006, where it says that any direction given on special facts in exercise of jurisdiction under Article 142 is not a binding precedent. And further, in these two judgments, Supreme Court has expressly applied, as stated, that the judgment will be made applicable to appellants who had not prosecuted their appeals, which Supreme Court has done in this case, but limited it to the writs which has been filed. As the wording suggests, we can still debate, and I am in a minority, I'm very sure about it. But this is an argument one should not omit. And as a from assessee's side, you may not accept blindly that this judgment will be applicable, and therefore all notices issued to you under old 148 is now deemed to be notices under 148A. For those 81,000, for sure, the notices under 148 are bad, because under Article 141, the law declared by High Court, approved by Supreme Court, is that the new provision will be applicable, and notices under 148 issued post 1st April 21 are invalid in law. I'm only saying is that by this, those 9,000 having gone to Supreme Court, having gone to writ, will stand to a disadvantage, because deeming friction will only be applicable limited to their case. I will rest this argument here, and let's move forward. Now, the next issue which arises from the Supreme Court is that whether the limitation under 141, under 149 will be applicable or not, which we partly touched. But I wanted to actually deal it in detail while dealing with 149, and therefore right now is the time where let us deal with 149 and come straight to 149. Now, 149 has subsection 1. It was amended. The earlier 149, if one can see, was saying that up to 4 years there was power to assess, and beyond 4 to 6 years they had a power to assess more than 1 lakh. Now, this limit of 1 lakh, in that sense, has been raised as 50 lakhs in the new amended 149. Now, 149 is on the screen. Subclause A of subsection 1 categorically says that for first 3 years, or for 3 preceding, or for the 3 preceding assessment years, the assessing officer has unlimited power to issue notices. Beyond, therefore, once any, so today, if forget for the controversy being 31st March 2021, as was before the Supreme Court, let's test it from that angle. So 31st March 2021, prior to that 3 years will be 2018, assessment year 2017-2018. So under A, they could have issued notice beyond that anytime under A, as on 1st April 2021, applying the new law. Second is that under B, they say that beyond 3 years and up to 10 years, you can issue notices provided the amount likely to escape is 50 lakhs or more. Therefore, putting it in the way that for an amount which is below 50 lakhs, beyond 3 years, which is as on 1st April 2021, which is AY 2018, you could not issue any notices. If it was below 2020, if it was below 50 lakhs. Now, moving forward, we will come to the final issues a little later. I'm on the aspect of limitation in terms of the years calculated. There are other thresholds which have been for the first time put under subclause B, which is very interesting and provides safeguard, but we will come a little later. The revenue post having power under A and B to issue notices, it has to cross the threshold of the proviso, the first proviso, which says in short that you cannot issue notices the day you issue a notice under section 148. Remember, 149, section 149 talks about notices under 148. There is no time period for issuing notices under 148A. Please bear this in mind. So, notice under 148A, the date on which you issue them, you have to see whether you could have done the same under unamended law which was applicable till 31/3/2001. That is up till Finance Act 2020. So there is second threshold. So if all remember that under the old law there is only 6 years period, which was provided, and therefore on 31st March or 31st March 2021, you could have only issued notices 6 years prior in time, which was up till 2015. However, therefore the assessee's view, which was that all notices thereafter are bad, the department is using reading TOLA into it, and therefore saying that because of the TOLA, under the proviso, you have to read the power to issue notices under 148 under the old regime was extended from 31st March 2020 to 30th June 2021, and therefore the filter under this proviso for applying the old law will be till 30th April 2021. Therefore, the chart goes this wise. Don't take this as my opinion. This is just for debate. For 13-14, applying TOLA, the department says that 30th/6/2021 is the due date. So is with 2014-15. The reason being is 14, 6 years completed March 2020, 15 completed March 2021, and as per them, both were extended till 30th June 2021. And therefore, under the first proviso, you have to see these dates as the cutoff dates, and therefore notices issued before that will pass the muster and the test of proviso, and therefore all notices under 36/2021 are valid in law. Now, coming to the wordings of the provision and the TOLA for that matter, to understand and to deal with the controversy, to have this controversy resolved, as I told, the High Court order has to be read. If the High Court order is read, which I will just put across, there are only two, there are three beautifully written judgments: Allahabad, Delhi, Allahabad, subsequently Rajasthan, and thereafter Delhi. Thereafter Delhi. Now, if you see Allahabad High Court, I'm just reading two paragraphs of Allahabad judgment. So, in Allahabad judgment, para, is it visible on the screen? Is it visible? Okay, so assuming it is visible, I'm just reading it. Para 71, 72, and 75 and 76 of Allahabad judgment in case of Ashok Kumar categorically refers that reference to assessment proceedings with respect to pre-existing and now substitute provisions under section 147 and 148 of the Act has been introduced only by the later provisions issued under the Act. Therefore, the validity of those provisions as is also required to be examined. We have concluded as above that the provisions of section 147 to 151 substitute by old provision with effect from 1421. We have further concluded in absence of any proceedings of reassessment having been initiated prior to 1/4/2021, it is the amended law alone that would apply. We do not see how CBDT could have issued the notice plainly to overreach the principal legislation, which obviously is the Finance Act 2021. Unless harmonized as above, those notifications would remain invalid. Now, 75. As we see, there is no conflict in the application and enforcement of Enabling Act and the Finance Act. Juxtaposed, if the Finance Act 2021 has not made the substitution to the reassessment procedure, the revenue authorities would have within their rights to claim extension of time under the Enabling Act. However, upon the sweeping amendment made the Parliament by necessary implication or implied force, it limited the applicability of Enabling Act, which is TOLA, and the power to grant time extension thereunder to only such reassessments as had been initiated till 31/3/21. Consequently, the impugned notices have no applicability to the reassessment proceedings initiated from 1st April 2021 onwards. Then 76, upon Finance Act enforced with effect from 1/4/2021 without any saving of the provision substituted, there is no room to reach a conclusion as to the conflict of law. It was the assessing authority to act according to the law as existed on and after 1/4/21. If the rule of limitation permitted, it would initiate the assessment proceeding in accordance with the new law after making adequate compliance of the same. That not done, the reassessment proceedings initiated against the proceedings are without jurisdiction. So therefore, and at the end, the Supreme Court, by way of its operative portion, at para 80 says, in view of the above, all the writ petitions must succeed and are allowed. It is declared that ordinance, the Enabling Act and Section 2288 of Finance Act 2021 as enforced with effect from so and so are not conflicted insofar as the explanation amended to clause so and so and improved notification dated 31/3/2021 and 27/4/21 respectively are concerned. We declared that the said explanation must be read as applicable to reassessment proceedings as may have been in existence on 31/3/2021, that is before the substitution of section so and so. Consequently, the reassessment notices in all the writ petition are quashed so and so, and it is left open so and so. So, reading these, it appears two things, that in the main portion, in the main argumentative portion, the Allahabad High Court has categorically stated that the extension of limitation is not permitted for various reasons it has had. However, in the operating portion, it has only held that the notification and the explanation therein, the explanation therein which we have just seen, is to be applied, and that is held, this explanation has been held bad in law. Now, the other argument of the revenue is this, that sir, if you have to apply the deeming provision, the concept of deeming provision is twofold. Supreme Court has applied a deeming friction. Deeming friction has two principles. One principle is that the deeming friction can only be applied to the extent it is meant for and no further. Second is that the deeming friction will have to be given its full leeway, and it should be taken whole hog to the extent it is made applicable. Therefore, it stands on two limbs. One is this, that the legal frictions are created only for some definite purpose, and the legal friction is to be limited to the purpose for which it was created and should not be extended beyond that time. Second is that what is obvious or what is uncertain, but in some cases the motive of the legislation would be relevant, and the relevance, the motive will have to be gone into for understanding the extent of the deeming friction. Now let us understand the motive. The motive here is not the legislation but the Supreme Court, and therefore strictly speaking the principles of interpretation of statute applicable to deeming friction may not stricto sense applicable to Supreme Court judgment. What is the motive? The motive is to balance the act, which the Supreme Court has said. The motive being to give a chance to Supreme Court, to revenue, to see that the exchequer is not harmed. The motive is to see that there is an opportunity to reassess, and there is not a case where the reassessment does not take place at all. So this is, if you consider this being the motive of Supreme Court, you tend to hold that the Supreme Court deeming friction will have to be taken to its logical end, which is to say that deeming friction of 148B show cause notice will be treated that it is issued on the date on which 148 notice has been issued to each respective assessee. For an example, if the notice to me was issued on 20th June 2021 under 148 and I went into writ, Supreme Court judgment applies. Supreme Court says treat that as 148B. Therefore, taking the deeming friction to its logical end, it will have to be treated that 148B notices was issued to me on 20th June 2021. That is what Supreme Court says. Now, what the revenue in the circular which is issued on 11th May 2022 says that everything will relate back. This is what it meant, that it will relate back and it will start from the day on which I was issued 148. Now, assuming that revenue is right, let us test it there. Now, revenue being right, let us start what now will happen. The Supreme Court has stated the procedure that on 20th June 2021, 30 days will be available to assessing officer for issuance of not reasons, but issuance of material and the document relied upon. Post that, 14 days will be available to the assessee to reply, and thereafter the assessing officer will pass an order under 148D. The timeline, let's start it and applying the timeline from that date. Now, if you apply the timeline, the Supreme Court has certainly said what we have just laid down the procedure, we have just analyzed the procedure. Would the Supreme Court also suggest that 149 is overruled? In fact, on the contrary, the Supreme Court has categorically kept all the defenses available to both sides very much open under section 149 specifically, which all of you have read in Supreme Court judgment. Now, therefore, applying those provisions, please see provision number 3, the bottom provision under on the screen, which says that the limitation will be excluded to the extent that the period which is available to the assessee to give his reply, which in this Supreme Court case is 14 days. Now, the first question which arises is, may I read that? Provide also that for the purpose of computing the period limitation as per this section, the time limit, the time or extended time allowed to the assessee as per the show cause notice issued under clause B of section 140A or period during which the proceedings under section 148 state. So first it says that reply period is to be excluded. 14 days needs to be excluded, agreed. Whether these 30 days provided by Supreme Court will also be excluded while computing the days from 20th June 2021, because even as per the revenue, the notice could under 148 could only be issued till 30th June 2021. Therefore, 10 days were remaining with them. Whether these 30 days provided by Supreme Court will be excluded, none of the provision under the first limb of this provision does not say so. It says only the balance 14 days. Let's read the second. Or the period during which the proceeding under section 148A is stayed by an order or injunction of any act shall be excluded. Now the question is this, there are various judgments. In fact, there are various courts, including Calcutta High Court and initially even the Gujarat High Court, who have not given stay. So just purely filing writ, the assessing officers, once the writ having been filed, they did not take action. Many of them proceeded with, but without stay, many high courts have issued pure notice. Does this 30 days period come within this period of stay? There is no stay given by High Court, post the High Court order and by Supreme Court, whether this 30 days will be excluded. The assessing the revenue under the circular 11th May wants it to relate back, and therefore these 30 days they want to be excluded. If these 30 days are excluded, then they still have 10 days and 10 days more. If this 30 days is not excluded, then 20th April plus 30 days, the time period of 30th June 2021 is lapsed, and therefore notice even post conclusion of first of order under 148 AD will not result into a valid within limit notice under 148 read with 149. Again, coming on the deeming fiction, can Supreme Court be deemed to have extended the limitation as provided into provision? Even going on the logic of deeming fiction, taking its logical hand, considering that Supreme Court kept defenses under 149 open, I would only say this much, that the law on limitation has already been declared by Supreme Court, saying that in Hope Textiles, this was under 153 of IT Act, the Supreme Court said that even we could not extend the period of limitation. If it has expired, it has expired. We cannot by order pass any extend the limitation. In ONGC versus GITCO, Supreme Court, while stated that even under Article 142 of the Constitution, we cannot extend the limitation that is there on the screen. So this is the law, and neither the Supreme Court has expressly stated in its order under Ashish Agarwal that the limitation is extended. Then whether it, in my view, the limitation will not be extended. The deeming fiction will have to be given its logical end. It will relate back to that date, but the period of these 30 days will not be excluded. In my case, this 30 days period will be counted in, and therefore I will any 148 notice read with 149, if in my case, in my example, will be beyond limitation. But at the same time, someone being issued notice on 1st April 2021, even if 30 days are included, there is a lot of balance period with which it have to play the role. This is taking the best case of the revenue ahead. Now, a very, very interesting point which I want to highlight, and that would be one of my takeaways from this particular session. Now let us see that what is another point. This is the new amended Finance Act 2022 provision of clause B of 1 of 149. Now here, what is in red, that is 2 and 3, have been amended with effect from 1st April 2022. But up till 1st April for the Finance Act 2021 only had the words which said that the chargeable income must be represented in form of asset. Therefore, to say that up till 31/3/2022, the notices under the amended law could only be issued for assets, for cases where there was asset-backed income. Please understand this. If it was non-asset backed, up till 31/3/2022, you could not have issued notices beyond that. Why do I say so? So, which are the notices, which are the financial year up till which you could have issued notices for asset backed or non-asset backed? So, those income or those assessments which had income escapable, which were which were not backed with asset, in my view, could not be issued post 31/3/2022. read with provision which is 6 years, with provision 1 which says 6 years. Why I say so? The Supreme Court judgment, in case of K.M. Sharma and Brahmdutt very categorically states that once the limitation ends, you cannot extend the limitation. So the limitation for the assessment period, that is up till assessment period 2019, that is 3 years prior to 31st March 2022, for those escapement income which did not have a backing of asset expired, and those expired assessments could not by subsequent law, which is not retrospectively applicable, be reinitiated by bringing in new categories which are non-backed asset income, in terms of backed with entries or backed with transactions, expenditure having transactions which is in 2 or 3. Therefore, as the second point which could be taken in argument is this, that any notices issued subsequent to 1/4/22 for non-asset backed incomes for a period beyond or prior to 2019 will be bad in law. Therefore, now this probably ends the discussion on the Supreme Court judgment. Will be open to queries. I quickly take and 2 more Supreme Court. Again, I'm backed with my interpretation. I'm backed with what is the scope of Article 142. That is very important while interpreting the Supreme Court judgment, as well as what high courts have held, because what high courts have held is been accepted as correct declaration of law by Supreme Court. These are the principles based on which one will have to apply the Supreme Court judgment on each assessment years and consider it. Now, considering the new provisions under 148, 147, 149 and 148A, just now analyzing quickly those provisions. If we see, this is the old procedure whereby after 148 issuance of notice, we could have asked reasons, we could have got reasons, replied, then order considered, order passed, that may be challenged or not. And while doing that, we had defenses of change of opinion within 4 years, beyond 4 years, that true and fair disclosure, etc., etc. So that all was because of this particular phrase which was used in the old provision, which said that the assessing officer should have a reason to believe. If on the screen you can see the comparison, the old provision had the phrase that assessing officer has reason to believe that any income chargeable to tax so and so, while this phrase reason to believe is being excluded under 147. One of the reason why this is excluded is that because entire process behind reason to believe is provided under 148A. So according to me, by taking away 140 reason to believe from 147, this ought to have been provided under 148A, because that is where everything prior to recording of reason or prior to moving ahead with 148 notice is happening now under the new amended law. The question arises that the defenses which were available, which in fact the Supreme Court also said in its judgment under Ashish, that the litigation relied upon whether the reason to believe were valid or not, there was a change of opinion or not. So here, since the phrase reason to believe is not there, my question arises is whether the reason to the change of opinion is a relevant concept anymore or not. If everyone recalls, the change of opinion is where the assessing officer in 143.3 in earlier assessment has already assessed the same issue, which again has been reopened under 147. The courts have held right from Calvinator to say that such cannot be done. Since the reason to believe is no more there, could change of opinion still be applied under the amended provision? In my view, the Calvinator judgment is very clear. The Calvinator did not read the phrase change of opinion or the concept of change of opinion because of the word reason to believe. It read because it held that the provisions under 147 provided the right to reassess and not a right to review to the assessing officer. Therefore, if under the new provision of 147, the concept has not undergone a change, the concept is still of reassessment and does not empower right of review to the assessing officer. And therefore, in my humble opinion, the change of opinion concept laid down by Calvinator and numerous Supreme Court judgments followed by High Courts is still as much applicable. Then the issue comes ahead is whether the information is required to have a live link or direct nexus to formation of belief for escapement of income. Now, as we have all understood that the concept of reason to believe has gone, but what has come instead of that? Instead of that, what in my view has come is this. This is section 148, new 148, which has again been amended in a big way. 148 says that the notice under 148 could only be issued provided that there is an information with the assessing officer which suggests that the income chargeable to tax has escaped assessment. So the phrase reason to believe has gone because 148A has been introduced, but it has been substituted in my view with the word suggests. Suggests in my view is not equivalent to reason to suspect. So therefore, is it only on suspicion that the information which gives a suspicion can be good to reopen under 148? In my humble submission, no, because what here is suggestion, what here the phrase uses suggests. It is not suspicion, not suspect. So if it could be seen that the reading of the use of different words, which is suspect versus suggest versus release versus believe, the word suspect used under information under 148 explanation as well as the proviso as well as 148A means, as per various definition, is something more than suspect. The what dictionary says that a surmise or representation of a thing, an entry or a fact on the record. So it has to be fact on the record. Cambridge says to mention an idea, possible plan or action for other people to consider. Then Britannia says that to say that something is good or deserves to be chosen, or to show that something is likely or true, is something. So therefore, it is much more than simple suspect. And in my humble full, the second takeaway from today's session should be that now, instead of the hook, reason to believe, we have a hook where we can apply the old principles or old safeguards under the old regime to the word suspect. That is now the new hook which is available to us, because reason to believe and reason to suspect, there is vast distinction with the phrase suggests. And till the information does not suggest, the information is not an information as defined in the explanation to 148. Now here I'm just reading 148, where the phrase information for the purpose of this section and section 148A, the information with the assessing officer which suggests that the income chargeable to tax has escaped assessment means so and so forth. Again, therefore, the suggest here has to not be assumption, not be suspicion, not be vague, not be something which is not having a live link. Suggest would mean that there is something which is there with the information and the escapement of income. So let me put it this way. Let me explain first the old law in a sentence. What old law did was, there are three elements. There was information, there was a reason to believe, and there was then escapement of income. The reason to believe was a linkage between information and the escapement of income. Information was not anywhere used in the old regime. In the new regime, reason to believe is not used. So out of these three, only two have been used. In the old regime, information was not used. Reason to believe was used, as well as escapement of income. In the new regime, information is used as well as escapement of income. Reason to believe, which was the bridge between both of them, is not there. But today the bridge is word suggests. Now, very importantly, the third takeaway, the third aspect of defense which is available. So every other defense, because of the paucity of time, I'm taking very quickly. In my view, right from the defenses of change of opinion, from vague or incomplete or not having live nexus, to borrowed satisfaction, which we will come a little later. Everything else will be also applicable under the new provision, except one, the safeguard which was with respect to full and true disclosure, which was the proviso, which was for beyond 4 years. That is completely given a go by, and under the new provision, that is not something which you can play a hook on. Now, if you compare the new provision and the old provision, the entire controversy today we are faced with is the notices which have been issued between 1st April till 31st March 2022, as well as that period of till 30th June. So for that, one very important distinction is this wise. There are two major amendments which have been made by Finance Act 2022. One is addition and modification of explanation 1 to section 148, which defines information, where earlier up till 31/3/2022 that is Finance Act 2021, only gave two criteria, which is on your screen, while Finance Act 2022 provides three more criteria, and therefore that is one thing. Therefore, the Supreme Court, if you read Ashish Agarwal, it categorically says what will be applicable to all these notices will be the provisions of Finance Act 2021, and therefore these amended provisions of 2022 will not be applicable. Similar arguments can be taken as we saw in case of section 149(1) clause B, where up till 31/3/2022 by Finance Act 2021, only the income backed with assets were assessable, while others were not. Post Finance Act 2022, which is effective from 1st April 2022, other two categories have also been added, and which has not been made retrospective, and therefore it can very well be argued that such amendments of Finance Act 2022 cannot have a role to play in while deciding, and all those notices wherein the income is not covered by the information provided under 1 and 2 by explanation, which is that it is by a competent by an audit and by CNAG. Suppose, for example, there is an audit which has been done as a special audit. Now that special audit gives some findings that otherwise becomes an information, but that information will not be an information for purpose of assessment for these under Finance Act 2021. So that audit will not be an information here.
तो अभी तक के पुराने वाले जो चालान जनरेट होते थे वो किस नाम से हुए हैं?
I'm sorry. I'm sorry.
Please continue.
Yeah. So that is just one example. Second example here is that risk management strategy. So things which are flagged in risk management strategy are the only basis on which, only information basis on which the 148A can be done. The Supreme Court nowhere, even extending the deeming friction, overturns the substantive law, bringing in the old information concept, reading it into 148A with explanation 1 of 148. Therefore, both reading Supreme Court judgment, reading the circular dated 11th May 2022, both say categorically what is made applicable is Finance Act 2021. You can't travel beyond that. Therefore, what is flagged is something which is not available in public domain in that sense. All those investigation reports, all those informations from other SSCs, other assessing officers, which our assessing officers have received, informations by way of audit other than CNAG, various other Panama leak papers, information which have been generated under Section 90, judgments from GST Act or raids under GST Act or under various acts, until it is a part of subclause 1, will not form the basis of assessment of these particular notices up till 31/3. We have to be very, very careful while dealing or while replying here. Now, while replying, you must also consider that don't go whole hog in giving your response by making him aware about all the limitations which he has given in his show cause notice and the reasons recorded. You have to say but you have to be at the same time disguised, and it has to be very, very beautifully drafted and very carefully drafted, because earlier he had information, he had recorded the reason, post that 148 was issued, and we therefore had something to test in form of reasons to believe. In the new provision under 148A, there is no reason to believe. He, after inquiry, if he deems fit, he will go ahead and issue show cause notices. That show cause notices will provide the basis material to us. SSA will reply, and thereafter, considering the reply and what is on record, he will thereafter pass a fitness certificate, in that sense, if I can use that word, to say that this is a fit case for issuance of notice under 148. Therefore, the entire reason to believe, which was prior in time of our objection, has shifted to post our raising of objection, and therefore it is much more leeway available to him to improve upon his order passed under 148 AD. So do not educate him more, but at the same time take relevant defenses in a very disguised manner, or in a manner which tells him but does not give him enough way to improve upon. So that is one important suggestion. Third important suggestion is that if you see in 148 A, in 148A, what is here is provided in B, that this is what is amended as per 2022. This is an old act, where if you see in B, the prior approval of specified authority is mentioned under 148B. However, under Finance Act 2022, this has been removed. Therefore, by issuing show cause notice up till 31/3/2021, he has to take a prior approval of specified authority under B, which is not there in subsequent amendment. However, in Supreme Court has only deemed the approval under clause A to be deemed. It has not deemed approval under B as deemed. And believe me, having appeared for 4 odd years and thousands of matters for department, in 30 days it is practically impossible for them to revisit and to implement the law the way we have understood and actually the law to the assessing officer and get it implemented in 30 days and get the issue. So this will be a lacuna. So you must call for all such approval, because this is not something which has been deemed approved by Supreme Court. Next is this is again one defense which comes to my mind. There are now what happens after 148D? Now 148D, the earlier concept of Supreme Court in case of or Gujarat High Court is in Garden Finance, or in Gene Knit Private Limited for of Supreme Court, where it has held that the objections disposing of the order disposing of the objection is amenable to writ. In light of that, my view is that orders under 148D will also be amenable to writ, provided you can show that there is a lack of jurisdiction, there is a non-application of mind, there is no nexus with the material, there is a change of opinion, there is no information as defined in explanation 1 which could form the basis. All these arguments, if raised and not dealt with, and also one more, that if required, if the personal hearing you have called for, you have not got, then again you can say so. If your The Supreme Court categorically says that the reply of the assessee will have to be considered. The provision says that if you see D, that material that decide on basis of material available on record, including reply of the assessee. So if he has not considered or dealt with your reply, then also, in my view, it would be maintainable. Today, fortunately, the High Court is brave enough, as shown in so many judgments, that it has quashed as many as 9,000. So the impact is 90,000 notices quashing. Now, in fact, I wanted to in detail analyze each section of 147. Organizers, how much time more I have?
Sir, we can continue or take the queries in the question answer session also.
So, can I do one thing? I'll continue for 10 minutes and then answers so that I can really complete the leeway between the comparison between both of them.
Definitely.
Right. Old and new law. So therefore, the questions will also be very easy to ask and answer both.
Right, sir.
Now, whether information as defined has to be tangible. The question is tangible or intangible will depend upon the nature of the information. Today, can the information which was already available with the assessing officer be used against the assessee? In earlier law, no, because full and true disclosures was a criteria. In today's law, it can be, subject to that it is not amounting to a review, which is change of opinion. Very important. In the order under 148D, you will have to see that whether it is a borrowed satisfaction or not, which means that if the assessing, if you can from the order show that he has, assessing officers bodily lifted the suggestive material, you see there that there is no application of mind of his, wherein, for example, the information suggests that there is a capital gain which is arising on the stock. Let me put it this way. Now, he bodily lifts it, goes ahead and holds that there is, let's say, what was suggested was a crore of capital gain, while in our case, in reply, the assessee has shown that two things: A, that the script which is considered was not there, or the assessment year what was alleged was not there in the show cause notice. C, that the amount was not 1 crore but absolutely something different. And after pointing that, still if he actually adopts exactly how it was suggested in the information, it is a borrowed satisfaction, which you can very well use. Now, a very important point which also comes across is in the old law, if you remember, the audit objection. Now, again, in the there is a distinction, two distinctions here in the in Finance Act 2021 and 2022. In subclause 2A, the Controller and Auditor General has been removed. Any audit has been word stated. And second, here if you say the final word, any final objection raised by the control, so word final has been removed. So any objection in the audit report. Now the word final has been removed. So having again with my experience with as an advocate for department, what used to happen, what is the modus operandi is this, that a assessing officer does not have time in his life to take over the assessment proceedings of an already assessed year or an assessee, and revisit, re-verify. He never does that. It is the work of audit department which takes out the assessed or unassessed past years, points out to the department, points out to the jurisdictional assessing officer that see, this is the mistake which you do. The assessing officer then has an opportunity to reply to that audit objection, which is called preliminary audit objection. He can reply that yes, it is a mistake, or he can justify that no, the original assessment done was right for XYZ reasons, and therefore please drop your audit objection. In past Supreme Court judgments have, the High Courts and Supreme Courts have held that if this is what is being done and the audit objection has not been dropped, even after it being opposed by the assessing officer, and thereafter if the notice is being issued under 148A, 148, it will be bad in law. In my humble full submission, even if the final word is removed, what will be the basis of the process will only be the final audit objection. So therefore, this word final word being there or not being there does not make any difference. It cannot be the preliminary audit objection which can form part of it, because it has to, because the assessing officer has not even applied the mind and he has just borrowed it from the audit party and went ahead. So therefore, even under the new law, such audits objections opposed will also be amenable to as if it is non-applicable and quashed. Next is if explanation. Now yes, there is RMS which is there. Now for RMS there are no such public document which is available in public knowledge, but there are these two instructions which are there, which give some leeway to 15, 16 and AY 18, 19. It's broad, but it does not again specifically suggest what is the risk management strategy of the department. Can therefore we ask them if the risk management what is the risk management strategy? Certainly yes. In fact, the first response under 148AC of you should be that please suggest or please show us under which RMS or what are the RMS under which you have issued the information you have received and you have given a show cause notice. This is the right of the assessee to ask, and you must ask it. But that too again, not in probably all cases, because it is as per the Supreme Court and as per the reading of 148B, it is the duty of the assessing officer to provide the documents and what is relied upon by him. So earlier, as we all know, that we only used to get reasons recorded and not the statements, or for that matter other things which actually formed the part of the investigation report and the letter of investigation being coming to the jurisdictional assessing officer. Here he is bound to provide all of them if he has relied upon them. So if he has not relied upon them, he is not bound to give you. But then if he has not relied upon them, then you will have to ascertain that the papers which he has given to you, based on which the reliance is placed, is sufficient to form an opinion or suggest that there is an escapement of income. If that being not so, do not call for statements, because if you call for the statements. He has a chance to improve upon in his eventual order under 148 AD. These are some strategies while actually drafting and applying the law. So again, now 149, 148A we have dealt with. 149. Let me take. Okay, there is another controversy which let me take through. The controversy is this wise that under 148A there is an inquiry which he needs to conduct, and it says that if required. The Supreme Court, which is absolutely not required, was not required under Ashish Agarwal in the facts of that matter, held that this is not mandatory and it is the discretion of the assessing officer. So therefore, he must not inquire anything. I raise a question to myself that if he is not inquiring, then there are two kinds of inquiry. One, you receive material, you test it and inquire it with the material on record of the assessee which you have, and then go ahead, issue notice under B. Second is not having any, you do not have any information. However, you just are aware about some information which is there, but at the same time you want to conduct an inquiry to actually improve upon the information which is slightly vague. Now it is in that context that prior approval of specified authority would be required, where he will have to apply to the assessing office, to the higher specified authority, which under 151 has been specified as principal commissioner, principal chief commissioner. Now, the point raised is that if there is no inquiry which has to be held, then can it be considered as application of mind? Under B, the new provision has removed the approval from approval of prior authority, prior approval of specified authority. Therefore, it becomes more incumbent under A that while even issuing show cause notice, there is a prior approval which is taken, and in that sense, if it is not taken, then you can very well say that there is no inquiry which is done, and with no inquiry being done, the nature of the show cause notice and the material clearly shows non-application of mind, and therefore it will again, in my view, be a valid defense available to the assessee with respect to him or the assessing officer not conducting any inquiry. Putting it otherwise, under B, there is no provision of inquiry here. If you read, then there is no provision of inquiry. So could we say that without inquiry he can issue notice under show cause notice under B? So inquiry, whether, as I told you, is to find something more or is to apply the mind. If it is to apply the mind, he has to do it. It is mandatory. But if it is to find something more, to find some more document, he will have to take the prior approval to go ahead outside and find something. So for example, if he has got information that it is a penny stock from the systems, which whether it will form in RMS or not, it's a separate question. But tomorrow he goes ahead, goes on Google, writes to BSC or stock exchanges, tries to find out whether detail. For that he will require approval. But to say that comparing what information he has received with the documents, if he has not done, it will be a non-application of mind. I hope this is clear. Now, I have dealt with reason to suspect, reason to believe. Okay, this is very, very important. Now, what will happen, and what is my biggest uh, suspicion, though it should be suggestion, not suspicion, but here it is suspicion, is this, that post issuance of show cause notice to you, the grounds or the information will be amended. Why? So there will be a distinction or difference between the material while issuing the show cause notice to what he uses for issuance of orders under 148 AD. Could that happen? Under old reasons to believe, we all know that it could not be improved upon either by affidavit or by order disposing of the objection. We have all known, and the Supreme Court as well as High Courts have quashed any such uh, any such effort being made to improve upon the reasons. Under the new law, can he do that? Can he improve upon the show cause notice already issued? So the concept of show cause notice is probably alien to our 140, our income tax act, but is very prevalent in indirect taxes, be it excise, customs, service tax, everywhere, where the starting point is show cause notice, which is very detailed, unlike the kind of show cause notices which we are receiving now, at least the ones which I have seen being issued till date. The law developed is this, that if there is any amendment which is done to the show cause notice which changes the character of the original show cause notice or which adds a new basis, then the same is nullity in law. He can possibly, if available in law, he can issue a fresh show cause notice, different, but he cannot. But a simple amendment, for example, instead of 1 crore, there is a clerical error, he has stated 1 lakh, right? That can be improved. So such amendment which are clerical in nature can be permitted, but not substantive amendment. This is my view, and it is again supported with the old judgments where you cannot improve upon what has been stated as reason to believe, because that was the basis on which you initiated 148A show cause. Therefore, this puts importance to the very fact of issuance of 148A notice, because that itself puts a lot of disadvantage to the assessee if such safeguards are not there. It is not only 148 notice, but even the notice under 148, show cause notice under 148A, B, puts the assessee to a lot of disadvantage, lot of discomfort, lot of expense, and it must be treated and interpreted in the strictest sense and should be taken most seriously. And any vague notice must not be treated. So this was my case study, which unfortunately we could not take. Again, does the burden of proof change from new to old law? In the old law, the burden of proof that the income has escaped assessment was on the revenue. Similarly, in my opinion, the concept of 147 has not undergone a change. The wordings and the safeguards or the filters have undergone a change, and therefore burden continues to be on revenue to show that the escapement of assessment. And therefore, while replying under 148C, you have to keep this in your mind, that has the burden continues to be on revenue, has the onus shifted to you? If the onus has shifted to you must provide enough evidence, enough material to shift that onus back to him. But if you see that the burden has not been discharged, if the pendulum has not shifted to you, your reply should be that classy that the burden continues. It should be shown that the burden continues to be on revenue, and while saying things, you must not take on yourself the onus which otherwise has not shifted to you. The pendulum continues with the revenue. If it is not so, then how information was considered in terms of the audit, which was a celebrated decision of India and Newspaper Society, where it has the expression of opinion again on this expression of opinion, where it has stated that again, audit, if it is an opinion which has been expressed uh, by the audit or by the audit parties. So audit parties can say two, three things. One thing it can say that this is the law, and while applying that law, it can apply on the facts to say that this is the application of law, and therefore this is bad, and therefore you must reassess. In earlier judgments, in earlier law, the judgments categorically said that such application of law by audit party is not an information. In my view, it is an arguable case even under the new explanation 1, which has been added, that such expression of opinion, application of law will still continue to be to not be an information. Second, there can be a opinion which is expressed by the audit party to say on a debatable point. For example, there is a percentage which is applied as a percentage of profit, where the assessing officer has applied 5% of profit of the total turnover to assess. The department says no. There are other 2 cases where 20% was applied, and you should also apply 20%. In my view, that will not form an information, though it is an observation of the audit party, because those debatable points is where the assessing officer has already taken a view, and it cannot be a change of view. The information cannot result into a change of opinion where there are debatable issues. So all audits, therefore, in my view, will not result automatically as information and leading to issuance of 148A. Therefore, on each cases, we will have to link or live link versus nexus that we have heard. The word suggest itself contemplates linkage between information and escapement. That bridge is there, and the law continues it rather than believe it as just use the word suggest. Audit report, then DVO report. Again, this is not an audit report. So whether DVO report can be there under new law, my view is that under old law, certainly it was an information, but under opinion expressed by DVO was not an information, but the facts stated in the DVO report could be used as information. And here, unless it is part of RMS, it is not an audit. Certainly, it is not an audit. DVO report is not an audit, and in other provisions, it will not fall. So therefore, it is, in my view, not an information. Excise show cause notice is not an information in 140 in the law up till 31/3 in Finance Act 2021. In Finance Act 2022, it may be covered by the last clause. Again, the entire it is a matter of interpretation. that whether you will continue to say that the basis of material words used are any information which requires action in consequence of an order of a tribunal or a court. So let's say excise show cause notice, whether it will be a action in accordance of the order of the tribunal or court. A show cause notice by an authority is not a tribunal or a court. All authorities below the tribunal is not court or neither a tribunal. So DRPs or advanced ruling authorities, they are authorities. These are neither tribunal nor court. And even under the interpretation, this will not cover them. So as it is, it will not be there. But if this matter travels to, let's say, SISTAT, in SISTAT it is there, then it's a matter of interpretation. It can be argued both ways. I think the courts will have to test it. I would view and argue that it will not fall in this phrase as an information which requires action in consequence of the order. So requires action is something which has to be very specific. The order should say that there is an action which has to be taken by the Department of Income Tax on basis of this particular order. Similar words were also used under 153. Under 150. But there the word apart from that consequence of or give effect to any finding or direction is there, which is slightly missing here. Now, surveys, I think it's a survey and search are a complete different domain. Otherwise, also time was short. DDI information, investigation report, a very, very live issue for 2013 and 13 for 2013, 14, 14, 15, because that's the time where searches were taken place. In my Ambulbul submission, it's neither audit. You have to find out that whether it is flagged in RMS or not. Nothing is available right now in public knowledge that whether it forms of RM, only if it forms part of RMS and flagged on the date, flagged on the date of issuance of 148, which is now substituted. If it is flagged today, please understand, if it is flagged today, it is not an information. It should be flagged on the date of issuance of original 148 and which has obviously been substituted by way of date. Non-application mind I have covered, adequate sufficiency, borrowed satisfaction I have covered. I think there's a lot of covered, and I think it will be now repetition. Though I must say that I wanted to spend more time on analyzing both the provisions of the old and new regime, word to word, point by point. And today, I can only say that for replying to the notices today which were issued, you have to compare three things. One is the old law and the defenses available under the old law. Second is the law which is there under, which is amended by Finance Act 2021, and also compare the law which has been amended by Finance Act 2022, because then you will get a clear comparison and figure out where is that the legislature has tried to improve upon, which has no retrospective effect, and therefore those which have been improved upon is a lacuna for this 1 year where you can take an advantage. I have in my extended time tried to bring about a summary of this conclusion, this comparison. There are enough questions which are there, and I am very happy to take them. I wanted it to be interactive session, but it believes that the encompass of this particular subject is so wide, and thanks to this technical IT related issues, the time probably was less for an interactive session, but I would love to have questions and try to answer them, because that would be the learning from my side. Thank you for giving me this opportunity.
Thank you so much, Nitin sir, for wonderfully explaining in depth about the relevant assessments and the sections. Sir, definitely the burden of proof is on the department, but the onus lies on us to prove the information with the department is not perfect or not correct. So I request all the participants to kindly mention their queries if they have in the chat box. So one of the query relevant to Nagpur is in one of the case here, the famous group Vasankar group case, wherein the information available with the department was the police complaints done by the depositors. So that police complaint was in the interest of depositor that whatever accrued interest they have not received. So they have accumulated that amount, and the complaint was of that additional amount. However, the original investment amount was meager, very small. So the departments in the reassessment 147 notices for the extra amount, additional amount. So the burden of proof lied on the assessee to prove that that was not the investment amount. So in certain cases, what should be a professional do to prove how to prove that it is not my investment, or the amount was not accrued or not received by the assessee?
So, very interesting question. Now, the concept of such disputed, I will call it as a disputed income, where the assessee is saying that this is not my income,
Right.
while the department is saying that it is your income.
Right, sir.
And department is saying based on a third party information or evidence of what or that matter whatsoever. It will be very important if the assessee could highlight that there was an ongoing dispute on this issue, and that dispute must be brought in your reply before the in your reply to whatever notice, whether it is assessment or reassessment proceedings, either of them. If that is brought, then there are various Supreme Court judgments saying that this is not a real income. Though interest is something which is which accrues by time, but at the same time, it is not a real income. Right from Godhra Electricity Company to various other judgments, and the onus on the professional will be to just shift the pendulum if it is to the extent of notice, reply to the notice. In assessment proceedings, a detailed assessment proceedings, you will have to go whole hog. But while replying under 148 AC, you will only have to do enough to shift the pendulum so that he deals with it in the order and makes mistake there. Because today what has happened is, by cleverly bringing 148A into play, the period for assessment available post notice of 148 is humongous. Because everything else which essentially took time in assessment before passing the final reassessment order was this process of issuing notice, replying, order, thereafter, disposing of it, challenging that. That was consuming a lot of assessment period time, which is 153. Today, that is available entirely and completely. So what will happen as a consequence is that department will get much more time. We thrived upon, the fraternity and the assessees thrived upon the mistake which the assessing officers did while passing the assessment orders. And that was primarily because it was absolute lack of time on their part to analyze the information, replies, and have a good, appropriate, suitable assessment orders. That will now be available. So you will see the 148D orders and the information being very, very bad. Those will be very, very clumsy because you have to issue notice under a time limit in 149. So that entire 148A will be quickly, badly, vaguely done in my view, in my experience on the other side. But assessment orders today, more assessment orders, in my view, will be less amenable to appeal.
Hmm. Thank you, sir. Sir, one more query is there. The extended period of 10 years under section 149 is applicable where the escape income over 50 lakhs represented in form of asset. The definition of asset in explanation defines it includes immovable property, shares, loan and deposits. Then whether the gold, jewelry, cash, machinery, etc. is out of the purview of extended period available. And the second question is whether the definition of asset in the explanation is inclusive or exclusive.
Very, very nice question. See, the word, how it is defined is asset shall include. Generally, the way it is that asset includes, that is how it is used. But here, see, asset is a very wide connotation. So it otherwise will include jewelry for sure. Right? There is no doubt about it. If it was undefined, jewelry would have definitely been covered. But since it is defined and the word and includes is used, the query comes whether jewelry and etc. will all be covered. You must certainly take this point as a matter of argument. But the word and suggests that there is something already there to which something else is added. And therefore, to say that asset in its normal connotation will include what it includes and shall also include what has been already mentioned, which does not definitely have jewelry as part of it. But in my humble submission, my opinion, this must be one of your defenses, but the advice or complete reliance on that should not be there.
Thank you, sir. Sir, one more query in case of reassessment. Nowadays, in terms of crypto, the officers are sending queries after receiving the information from exchanges. So my query is whether the this purview will include the foreign exchanges as well. If the Indian citizen has invested in foreign exchange and they receive the information, whether that information will also be considered.
Very, very interesting question. See, asset will as such include foreign exchange also, right? Cryptocurrency is on a different pedestal. Cryptocurrency, in my view, if you see the concept of cryptocurrency, which we are advisors to lot many exchanges and various other people who are doing that. So we have in detail in that studied it. The concept of cryptocurrency as prevalent is actually not a currency. There is a difference between currency and a token. Most of them are tokens today. I mean, I don't want to get into deep into it. Cryptocurrency, though you use cryptocurrency, it is an asset. It's just like shares. It's a quality of asset. Just like a shares, debentures, bonds, whatever you want to use that, which is tradable on exchanges. It is exchangeable. Some people till it is not given a color of legal tender, it can't become currency. In India, it has not been given legal tender and will not be given. At least bitcoins and such will not be given Otherwise, the very wand with which RBI and government controls the economy will completely disappear, especially in our kind of economy where the disparity in income is so vast that such is the tool of controlling currency which is used. Like for inflation, what is it right now? It is because the cash and the currencies were under the control of RBI that they can think of reducing the interest rate, and therefore inflation and other means of holding the cash with the banks and all and other monetary measures, which will not be available in currency, in cryptocurrency. And therefore, it is very, very difficult for cryptocurrency to become legal tender in India. But in some countries, it has already been declared. I think in 2 countries, it has been declared. One certainly, Estonia, it has been, and one more. But any which way, it is a currency for Indian purposes. It is not a currency; it is an asset, and therefore it will qualify as an asset. But at the same time, you must use as a defense that it is not an asset. Let the matter travel.
Thank you so much, Nitin sir, for wonderful deliberation. I know there are a lot of queries in the minds of participants. On behalf of participants, I request, sir, we will send the queries over mail. Kindly resolve the queries. We will further forward it to the participants.
In fact, if any of the participants would want to express their views or slightly for 2-5 minutes deliberate on the impact of Supreme Court judgment for AY 2013-14 and 14-15, I would love to do that, because that would be a learning which I'll take back also. So if anyone has views other than what I've expressed, or probably even seconding my views, I'll be very happy to know them.
I request any of the participants want to speak on the Supreme Court judgment. Rajay sir is also there, who is instrumental in bringing Nitin sir here. Yes, Ratan sir, I think you want to say something.
Sir, my SSC has received notice under section 148A as well as notice under section 148 on email ID which was used by the SSC in the year 2014-15. Right now, he has received on the email ID which was previously used on 14-15. Thereafter, the SSC has changed the email ID, the profile. So he has not received the notices. What the SSC is supposed to do in such circumstances, sir?
Sir, there can be 2 things. One, SSC has received notice or SSC has not received notice. If even in old emails, if that is continued to be used, maybe very sparingly by the SSC, even if that was a valid address at that relevant time, which is very sparingly used by SSC, it will be a valid notice. However, if that notice is now no more your domain email, if that email is no more your domain email in your control of your SSC, and if that email has received, it is not service to you.
Actually,
do you own and control the email or not? If yes, yes. All what you can say is that the date on which you discovered, or for that matter, if you have already provided a alternative email to the department, you can very well make out a case to say that the communication email is this email, and therefore notice has to be done in a particular manner. If a notice is required under law to be done, then it has to be communicated in a particular manner. And therefore, in my view, under 292B also, it will not be curable if you raise the issue immediately.
Actually, sir, that was the email ID of that accountant when the online system was started, and thereafter in the 2005 the SSC has changed it. So the department has sent the notices on the erstwhile email ID of that accountant, and that has not been received by the SSC.
So one thing is very clear, that it is not your email, right? Now let's test it second wise. Have you intimated an alternative email to them?
Yes, sir. Absolutely.
Then there is no, then it is not a service. Then it is not a service on the date on which you have received it. But at the same time, if you how you came to know that you have received it?
They have physically served me the notice under section 148. Thereafter, I have gone to in the profile and I saw that the notice has been served on the erstwhile email ID, which is not used by me. I have neither given it in my return of income nor on my profile status.
Very
That
good.
email ID.
I think then you can very well treat it as notice not being received by you, and you must take that plea immediately, and not once, if you accept it and not raise that plea, it will be a deemed acceptance, and that issue will not be available going forward.
Thank you, sir. Thank you.
Thank you so much, sir. Friends, if there is any further query, quickly we can take it. Or we can send a mail to Nagpur branch as well. We will further forward it to Nitin sir. On behalf of Nagpur branch, I would like to express my sincere gratitude to our chief guest, PC Sarda sir, for sparing his valuable time and coming today. I also thank our speaker, CA Advocate Nitin Mehta sir, all way from Ahmedabad. Now he is in Hyderabad, for sparing his valuable time in his busy schedule and coming and deliberating for such an important and critical topic. Thank you so much, Nitin sir. Thank you all the participants for coming in large number. Thank you so much.
Thank you very much.
Thank you.
Good session.
Akshay, just one thing to add. Nitin sir, we wish you a very happy birthday in advance. You have had taken out time before your birthday. Even if you're not well, still you have spare time. Thank you so much, sir.
Thank you.
Thank you for the opportunity.
Thank you.
Thank you so much.
Happy birthday.
Thank you.
Thank you.